Some people are asking, well, my son is 16 and he got into some trouble. They're just going to never mind, right? I mean, this is a low-end offense, and I'm here to tell you that teenagers are treated more and more seriously. The current government has changed the legislation, the Youth Criminal Justice Act, to make denunciation and deterrence a sentencing principle, essentially meaning that they're treated much more like adults when they're found guilty of offenses. In terms of defending a youth case as opposed to an adult case, there isn't a tremendous amount of difference. Lawyers go through the same process. So let's talk about that process. In the overwhelming majority of cases, contact to a lawyer's office happens after the person has been charged or while they're being charged. In the odd case, a parent usually will contact my office preliminarily to get some advice on how things aren't going well at school, that kind of thing, or they've been called by the police that they want to talk to them, and then a telephone call comes into my office. And so that phone call can sometimes precede the involvement of police, but more often than not, it's afterwards. It's difficult to speak at length about the police interview. That could be the topic of its own video. For right now, let's assume that the person has been charged and they've been released from custody and have been given a court date. Well, in an ideal scenario, the lawyer becomes involved shortly thereafter, if they're not already involved. So call the lawyer, hire the lawyer, and then the lawyer will then explain what I'm explaining to you probably, which is that the first process is to get disclosure. What's disclosure? Disclosure is all of the witness statements, all of the police involvement, any surveillance video, any physical evidence. All of that stuff is written down by the police. It's their job. And nowadays it comes on a CD, and it is disclosed to the accused and his or her lawyer.